I am prepared to talk about the jury this afternoon, but I was wondering if there were anything that we didn't finish or say as much as we wanted to on the women in crime. And we were on the women in prison area and the kinds of changes that occurred there. I take it it's all right if we pick up some of the dregs of this morning. Are there any other questions or reactions or comments that anybody has? Okay, we've exhausted that one. All right, I'll put away that folder. Okay. Talking about the jury is something that matters to me a lot because I'm enormously impressed with that institution. I mentioned this morning that for the first time in my life, I actually served on a jury in Montgomery County a few weeks ago. And I was fearful that I would be challenged during the voir dire. And what happened was very interesting. One of the attorneys and the judge recognized my name and connected it with research on the jury. And so, you're called up and they confer on all kinds of things. And so the two attorneys, and the attorney for the defendant was a private attorney, and the prosecuting attorney and the judge and I were standing there, and I said, well, you won't control the jury, will you, if you serve? And I said, no, I'm really very interested in serving, and I will in no way try to control. I certainly won't say anything to anyone on the jury that I've ever written about this, and I would appreciate the opportunity to serve. And the defense attorney went over to his client, and he didn't put his hand over the mic. So while he was whispering, nevertheless, several of us heard. He said, I suggest that we keep her, because after all, she's a professor and a teacher. She knows a lot about the jury. I don't think she'll hurt you. And so the judge got wind of some of this and said, you ought to put your hand over the mic because other people can hear you and so on. But anyway, knowing that I did know something about the jury, they nevertheless allowed me to serve, and I was very grateful. Of course, Shirley Abramson, who's on the Wisconsin Supreme Court, has served on juries in Madison, Wisconsin, and has written about it. So having lawyers and indeed judges serve on juries is now something that happens, not very often, but it happens occasionally. Anyway, my experience, it was a relatively minor property offense in which the defendant did not take the stand. He pleaded not guilty and so on, but it did go to a jury, and it was a 12-person jury. We went through the whole business, and in fact it took 2 full days of everybody's time before the whole thing was resolved. When I was through, I said, it's exactly the way I write about. And it was a very gratifying experience, because while I have observed hundreds, almost thousands of experimental juries, and looked at the Calvin Zeisel work on judges' reports about juries and read other people's accounts of juries, I'd never been there. I'd never seen it firsthand. And it was startling the extent to which the jurors in this case, in this experience, behaved as I had written about it and as I had hoped they'd behave. And in fact, as Hans and Widmer conclude in judging the jury. What do I mean by that? I mean that the jury spent most of their time talking about the record. They went over all the details of the case. They went over everybody's testimony. It wasn't a very long case. It wasn't a very complicated case. Nevertheless, they went over the whole thing. And as I wrote somewhere, the way the jury goes over the record is not in some orderly, chronological fashion. That is, they don't start with the opening arguments and go through all the witnesses' testimony and the closing arguments. Something catches their attention, something that a witness may have said or something, and they evaluate that. And then somebody will say, yeah, but remember the other guy said such and such. And I describe it as something like putting together the pieces of a jigsaw puzzle, that you focus on some little area and you put together the pieces that fit there, and then you may start in another section of the puzzle and work on that. And that's what they did in terms of going over the trial. But for the time they were through, they in fact recreated the trial. And they had gone over the opening and closing arguments and the judge's instructions with considerable detail. The other thing that I noticed happening was that sometimes there was a mistake that the jurors included in their comments. They made some factual mistakes. By the time they were through deliberating, those mistakes had been corrected. Well, in fact, the witness was in his late 20s. He wasn't an adolescent, or something else would come up, and so on. Anyway, I came out of, and the jurors also took that straw vote. They walked into the jury room. The thing that was different was, and I take it this happens now in other jurisdictions, instead of electing the foreman, the judge says, now the first person who is chosen for the jury and will sit in the box in the seat next to, or closest to the bench, that person will be your foreman. I don't know if that happens in other jurisdictions, so that there was no need to elect a foreman. But once we got in the room, the foreman suggested that we take a straw vote, and that, I assume, happened. Watched happen in hundreds of experimental juries. They took the straw vote. It was 10-2 in favor of guilty. Everybody then bent over backwards to say to the two jurors, you have the right to your opinion. Maybe we can persuade you differently. Who knows? Maybe you will persuade the rest of us that the defendant should be found not guilty. But let's start talking. And in fact, after about an hour and a half, one of the jurors who had voted not guilty said, "Well, I think I'm ready to change my vote." And a few minutes later, the second one did. In between time, one of the jurors said, there was a blackboard in the room. Let's put down on the blackboard what our questions are. What is it that we're not sure about, and so on. Anyway, they went through the whole process. They found the defendant, or we found the defendant guilty, reported the verdict. The judge then came in and talked to the jurors about the case, and they asked lots of questions about what wasn't said in open court. And the judge, somebody thought it meant okay, shared some insights that he had, and so on. And people felt very good about their experience. It was also a jurisdiction in which it was either one day or one trial. And so the jurors were also assured that now that they had served their day in court, that they probably wouldn't be called for another 5 years. But everybody really came out feeling that they had done a good job. And that was one of the things that used to characterize the atmosphere in the juries that I watched when we were working in Chicago and St. Louis and Minneapolis. We called it the kind of halo effect. First of all, the jurors would rise to the experience. They would use standards of evidence, ways of thinking that was different and better and more rational and more demanding than one would have in one's day-to-day evaluation. They would weigh their judgments, I thought, more carefully than the kind of judgment you would make in terms of how you evaluated perhaps a co-worker or your spouse or your children or someone with whom you had some commercial transactions. They seemed to understand that this was a very special obligation that they had. This was their chance as an amateur on a very limited, temporary basis to do something important. And they did it very well. That was my experience in my day in court, and that I was delighted to see was consistent with the research that Fred Strodbeck had done on civil juries at the University of Chicago with the Calvin Zeisel work. And they compared judges' decisions against juries' verdicts, and with the overall judgment that Hans and Vidmar make in their recent book, Judging the Jury. It's a wise institution. It serves the society very well. I know there are a lot of people, mostly lawyers who lost the case, who disagree with that. There is certainly, as I said this morning, a movement, and there will be again, and there have been several in the past, to do away with juries. Certainly to do away with juries in civil action. A very noted jurist in the 1930s, Jerome Frank, on the appellate bench, felt that it is so hard for us judges to figure out what's going on in the case. And we've had years of education experience, trained in the law. If we have such difficulty, how can we expect ordinary people
to follow the complexities of some of the civil actions that they're confronted with. And again, as I said this morning, in the late 1950s, there was another move, again I think led largely by some of the judges on the appellate bench, to do away with the jury, mostly on grounds that the kinds of issues that ordinary people and their fellow jurors were asked to decide were too hard, too technical, too complex, and that either the jury shied away from it by talking about, who knows what they talked about, maybe the last night's sporting event or something like that, but that they did not get in there and grapple with the issues. Of course, nobody knew what they grappled with. They were behind the closed doors of the jury room. Or that they based their decisions on prejudicial views, etc. You know, there was the whole view that the 13th jurors was prejudice and so forth, and what went on in the jury room was a kind of biased, narrow perspective that ordinary people would bring to situations coming out of their own experience. If they had had an injury and they were trying, looking at a civil case, they would be very skeptical of the plaintiff's back injuries or what have you. Anyway, there was very strongly the feeling that it was a waste of time, a waste of money, it was resulting in poor judgments and so on. Much of what drove the Chicago jury project at that time was the desire to make some kind of objective evaluation of the jury system. And I should say that when a lot of the faculty at the Law School of Chicago heard of the project, and some of them got involved with it, their initial bias, which many of us talked about, their initial bias was against the jury. Their initial bias was it probably was an outmoded institution. It was all very well to quote the Tocqueville and so forth, but that in fact the issues had become too technical and that they were beyond the scope of ordinary people. So far as I can tell, the overwhelming verdict, based on very extensive and careful scrutiny using all kinds of methods for analyzing the jury, has produced the opposite verdict. That certainly from the 1950s and 60s on, up until the most recent studies, the results all seem to be supportive of maintaining the jury system and of believing that it serves society well. Now, that doesn't mean there haven't been changes in the system, because as you all know, there have. It used to be that people thought there was something magic in the number 12. In fact, Beto did an article called Why 12 for the Jury, and he made some statistical argument about why that was exactly the right number. And Zeisel also felt very strongly that if you made the jury too small, and he thought really 9 was too small, that anything less than 12, was that statistically the chances of getting a broad enough range of opinion would be endangered, and therefore one shouldn't play with that. And I believe that Zeisel still holds that view, although all the studies that I have seen comparing 12-person and 9 or 6-person juries does not suggest that there's some kind of built-in bias or prejudice that one finds in smaller juries that you don't find in the 12-person jury. So there's been that change. The other change, of course, has been that not all verdicts have to be unanimous anymore. And so between the size and the unanimity rule, those are important changes. There's also been changes in terms of who can serve on a jury. Not very long ago, maybe even in kind of our lifetime, women could not serve. Could not serve on juries, and all kinds of other groups were either barred from service or would be most unlikely for them to serve. Also, the sample frame from which jurors were likely to be chosen has changed over the years. It used to be that the likely sample frames in many jurisdictions would be property holders in the community. And that has changed. Now most jurisdictions use voter registration lists. Some jurisdictions go beyond voter registration lists because studies have shown that there's some bias in terms of people who move more often are less likely to be chosen because you have to have a certain residency before you can
be a registered voter in a community, or that there's some bias against certain demographic and status groups in society, and that they're less likely to vote, and therefore their names will not appear. And during the controversial trials of the late 60s and 70s that we mentioned this morning, there were efforts to broaden the sample frame from which jurors may be chosen, to include welfare lists, to include driver's license lists, and so forth. And I think some communities have expanded the sample frame to include categories of people that might not appear on the voter registration list. So those, I think, are the major changes. Plus, it used to be that if you were of a certain profession, the chances of your being selected, or that you could most easily be excused for jury service, was much, much greater than it is today. That also goes hand in hand with the changes in time of jury service. Most jurisdictions, 20 years ago, even more recently, pretty much had a 2-week period of service. Now, you can do absolutely nothing in that 2-week period. You can sit in the jury pool, and a lot of women used to bring all kinds of knitting and sewing that they can catch up to. You can bring all your favorite novels. You could do puzzles, etc. But it was pretty much wasted, empty time. But you had to sit there, even though your chances, because of the particular occupation you had or whatever, your chances of being chosen for a jury were very, very slim. Now, with the 1 day or one trial, now of course you can end up on a trial that lasts 6 months, but that could have happened to you with a 2-week period. Now you know that if you're not going to get chosen, you're released after 1 day, and I think that makes the likelihood of people trying to get off jury service less. I've tried to look into that statistically, and I don't have a statistical answer, but it just would seem to make sense. And that was certainly one of the, are we being bombed, or is that thunder? Oh, okay. That's certainly one of the reasons why various areas went into the 1 day, one trial, was to not have to go through this whole business of people trying to get out of having to serve on the jury. And as I said, now, even if you're a member of the bench, certainly lawyers are called all the time for jury duty, and other occupational groups as well. Okay, those have been the major changes. I think that the questions that people ask about the jury, they ask them when we first started working on the jury project at the University of Chicago, and they ask them today, have been pretty much the same. It goes to the question of representativeness vis-a-vis the community. Are the jurors, in fact, representative of the community from which they've been selected? How important are the status and demographic characteristics of individual jurors in terms of the kinds of verdicts that they might reach? How motivated is the jury to carry out the job that it's supposed to do? How does the jury go about reaching consensus? How do they go about arriving at a verdict? There used to be all kinds of myths about what jurors do. They simply take a straw vote at the beginning, and that's that, and then they say, well, majority wins, even though you have unanimity rule. There are a great many questions about how the jury goes about reaching its verdict. How well does the jury understand expert testimony? I know that some of you in this room have served as experts in court, and you must wonder, does the jury know what the hell I'm talking about? Are they listening to me? Does it matter? And so on. And how well does the jury understand the instructions that the judge gives to them? Sometimes those instructions can be very complicated. To what extent do the jury's verdicts reflect the evidence and the rules of law that it was told to apply? And then there have been some studies that looked at size of jury and how that affects the verdict and length of time it takes to reach a decision. And what about the change from unanimous verdicts to either 9-3 decisions or even 6-3 decisions? How does that impact in terms of likely to find for the plaintiff or the defendant, or does that make yours likely to be pro-prosecution or pro-defendant in criminal cases? Do you have any data on that? And I suppose, how effective has the jury been in maintaining its independence from community pressures from the judiciary, etc., in particularly controversial or political trials. I understand that right now in Washington, a jury is being impaneled that in fact will be hidden from the court. There's apparently a drug case that's going to start very soon, the Edmonds case, in which they're going to, and I really have to know more about it because I'm supposed to appear on some program in which I'm either going to be for or against the procedure, but which they will, I'm not sure how they're going to do it because the jury, whether they will be in the courtroom and be covered over, or whether they will be in another room and they will not, and they'll see the thing over closed circuit TV, but the jury will be hidden from spectators and from witnesses and from everybody else because of the danger that somebody may try to get to them the way of influencing their verdict during the trial. I think that has never happened before. Does anybody know of any other cases like that? I think that's the first. So we will see. At any rate, those are the kinds of issues that people often look at and talk about on the jury. Many of these issues Calvin and Zeisel try to respond to in their work. I've tried to respond to in my work over time. Strobeck has looked at. There have been people at Michigan who've done work on juries, Wisconsin, the Penrod studies, and Michael Sachs's work at Boston University on the jury. The jury is a subject of enormous fascination, and a great many people have studied it in all kinds of facets, in terms of bringing in university professors to serve as jurors, obviously using students as juror surrogates is a very common thing. Putting role players in jurors has been very common, and so forth. And one uses the jury, as Strobeck did and others, as an example of any kind of small group trying to reach consensus. How do you go about it, and so forth. So there have been lots of different ways of studying the jury. I think that the use of the experimental juries and the way in which Strobeck designed it still remains the model. For those of you who don't know, let me say it, because even the work that's being done now, to the extent that people can go ahead and use this design, it has turned out to be the most effective. I say the extent to it is because it is enormously time-consuming and very expensive. Okay, what are the elements in that design? And that is, at the very beginning, you have a choice. You use real people who could or are, in fact, serving on juries, or do you use juror surrogates? And so you have a choice of do you use students, or do you use people from the community who you might pay to participate in the experiment, or do you try and operate in as close to the natural setting as possible? And it's many ways easier if you can do as psychology professors all over the country have done for years and years and years. That is, you have your pool, your subject pool, and you bring your subjects in. They're usually college sophomores. That is certainly characterized, and this is not denigrating anything, this is characterized much of some of the best work in experimental psychology, certainly all the attitude formation study and the pre- and post-experimental work. You bring in college sophomores, you give them some kind of stimulus, and you have an experimental and control group, and you watch their reactions. Well, that's been done looking at jurors as well. But I think to try and say one can't generalize, and maybe we'd be a little nervous about generalizing from students to people who in fact are called for jury duty, and in fact the whole atmosphere of participating in a jury means more than just being told, let's make believe this is a trial, let's make believe you're jurors, let's make believe that this professor is in fact the judge, and let's make believe that your deliberations matter. That's a lot of let's make believe. And maybe by the time you're through with all that, you've not simulated a jury, you've simulated a group of university students working out an experiment. At any rate, what Strobeck did, and which I then used in my work, and others have followed, and in fact taken it even further, is we gain the permission of judges in various jurisdictions, and for people who are ordinarily serving And this was when there were lots of people wandering around jury pools, when people were already called for jury duty, and they were serving their 2-week period, or whatever the time was. With the cooperation of the courts, we were able to take 12 of those jurors. We would, spin the wheel and pull out 12 names, and they participated in some special period of jury service. That special thing was that we took them into another courtroom. They were instructed by a judge in that courtroom that today, instead of hearing a regular trial, they would hear something different. They were still under the jurisdiction of the court, and the judges of this court were particularly interested in the results of this kind of work. Now, it's very interesting because, having worked with so many lawyers who always kept whispering, none of them have to agree with this. Any one of them can say, I don't want this. I was called for jury service, and unless I'm going to serve on a real jury, I don't want to be a guinea pig, and they could have opted out. In fact, over the 10 years or so that we were involved in this kind of research, no juror ever said, not me. Now, maybe people were just too cowed, I don't know. But at any rate, all the people that were selected at random from within the existing jury pool agreed to serve. And what we did was, and this may be simply a matter of expense and technical skill at that time, we exposed the jurors to an audio tape of an edited trial. Now, Penrod and Hasty and others at Wisconsin and some other places said, why use an audio tape? Why don't you allow the jury to see a trial? Because after all, when you see a trial, you can pick up all kinds of facial expressions. You can get a better basis for evaluating various witnesses, etc. Wouldn't that be better? Maybe so. We had, in addition to money and technical things, we thought that somehow an audio tape, you darken the room, etc., it induces a more passive response on the part of the people who will be asked to then deliberate, and that the audio tape with the lights on and so forth kept people more alert. I don't know, it's a question call. Nobody's ever really compared which are more realistic stimuli. But the important thing was that these were real cases. In the work that I did, I looked at issues affecting the defense of insanity, and in fact the first case that we played before 30 different juries was based on the Monty Durham case. And I had the record of the Monty Durham case, which is the basis for the Durham rule, etc. And in any trial that takes a couple of days, even 3 or 4, you can probably cut it down by eliminating repetitious witnesses and so forth, so that you can have a tape that has the essence of the trial, and the tape would last about an hour and a half, and then you'd have opening and closing arguments and judges' instructions. We did essentially this in a whole realm of civil actions and on some criminal cases. And the other kinds of things that we did, which we thought added realism to the experience, and we thought realism was very important, is the jurors were under the jurisdiction of the bailiff and the court, that they had a lunch break in which they were told not to discuss the case. But of course this gave the jurors a chance to get to know each other and to know something about what roles these people played in the larger community. And so you found that you had vice presidents of major corporations among your fellow jurors. You had unskilled laborers. You had people of various walks of life and so on. And then in addition to the opening and closing arguments and the judge's instructions, you also had expert testimony, plus you had, and this only either a tape or an audio or visual tape would allow you, and the opportunity to play the same trial before many different people. We introduced systematic variations in the same basic trial, so that you could have an automobile accident, but you can have the accident caused because the driver went through a stop sign or a stop light or some other thing. You could have a situation in which he left his keys in the car and somebody else was driving his car. You could have a situation in which you vary the amount of damages that were asked, but the facts remain the same. You could have variations in the expert testimony. You could have variations in whether insurance was mentioned or not mentioned. You can have variations in the instructions that the jurors were asked to apply, etc. What's the purpose of all this? To see what's important in various cases, what matters. And here we were guided very largely by the lawyers. That is, we said, what do you want to know about tort and how jurors respond to tort actions? What do you want to know about how jurors respond to various kinds of criminal cases or defensive insanity actions, etc.? What's important? Well, a lot of the lawyers said, we don't think the jurors understand a thing about those instructions. Okay, let's vary instructions and see if it makes a difference. Expert testimony, forget it. All right, let's try variations in expert testimony, and let's see if some have more impact than others. What do you think happens when a jury hears that, in fact, the plaintiff has no insurance? Does that hurt the plaintiff because how can he be so negligent, or does that help her because he says, well, he's a good citizen, etc.? Well, we did introduce all kinds of things, and in essence, you could play each version of the trial a number of different times, so that when you're saying, did something make a difference, you had more than one replication on which to base your decision. And so, in fact, we would have, in essence, the same fact situation, but we would have six different cells, and we would play each version 10 times. So, in fact, we would have many replications for each cell, and we could say at the end of it, with more reliability than I think most people, on a one-on-one basis, that here are things that matter. Here's what jurors pay attention to. Here's the kinds of things that they take into account and to what extent they take it into account. Okay, in addition to that, we did something else. Remember, these were cases that had already been decided. These were tape versions of trials that had already been decided, and therefore we recorded the jury's deliberations. And in addition to recording what everybody said, we had an arrangement whereby someone, an observer, could be in the room, but we had the person really like being behind that TV camera. The jurors knew they were there, and they knew they were being recorded because the mics were right on the table. This was not no hidden mics or anything. And the person who was in the room recording also could identify by number which jurors started to talk to whom, so that by the time we were through, if you wanted to, you could listen to that deliberation, and sometimes they took hours, and know exactly which juror was more likely to talk to which other juror, whether if there were several conversations going around the table at once, how the jurors clustered, which jurors spoke more, and when I say which jurors spoke more, we then knew the occupational background and the racial and ethnic background and the income and everything else about the juror, so that we can say, well, if you're used to talking a lot, if you get professors, for example, on a jury, or if you get people who are executives and they're used to running meetings, and you notice that one, they're most likely to be elected foreman, and two, they're also most likely to talk the most, that's not unexpected. And if you notice that some people hardly say anything or talk much less than others, is there something about their prior experience that they bring with them to the jury that would make them more reticent to speak up in a group? Well, we did all those things. We, instead of running the regular voir dire by which you challenge jurors for cause or peremptory, we gave them a questionnaire. And in the questionnaire we asked anything that any good lawyer would ask on an extensive voir dire. That's where we got all the background stuff on the jurors, and we got some measures of how they felt about the law and how they felt about some issues in criminal justice, if it was a criminal trial. We had some notions about any prior experience that they may have had on the jury, whatever the kinds of things that I think you think would be most relevant. In addition to that, before the jurors started their deliberations, we handed out a ballot, and we said, suppose you had to make a decision now, and suppose you were deciding the case alone, how would you decide? So we had a pre-deliberation individual measure of how jurors would have decided the case. And they went in and deliberated, and at that time the world was simple. All the decisions had to be unanimous, or else you'd be a hung jury. But we knew how every person was voting on straw votes and so forth, and then we knew what kind of coalitions were being formed, etc. And then after the deliberations were over, we gave out another set of questionnaires in which jurors were asked to, well, now that the deliberation is over, we know the verdict was unanimous, did you agree with the verdict? If it was up to you, would you have found differently? So we could then compare how they felt before they went into the deliberation. We know how they voted. So how do you think now? And that was a way in which we could look at whether people were persuaded or coerced. For example, you're persuaded if you think the guy is not guilty before you go in. If during the deliberation you start voting guilty, and afterwards when you're asked on that post-deliberation questionnaire, well, now how do you feel? And you also vote guilty, so your pattern looks not guilty, guilty, guilty. It's, I think, reasonable to assume that you've been persuaded by things that you heard in the deliberation room. But you could have a pattern where people started out not guilty, somehow they got a unanimous verdict, and then when you were asked, well, how do you really feel about the case, they could have gone back and said, I still think the guy's not guilty. And we, when we saw patterns like that, would say, these people were coerced. Now, they weren't always holding a gun to them, but either because they were anxious to get out of the jury room, enough was enough, or because they couldn't hold their own in the arguments or what have you, we can look at a pattern like that. And of course, one of the things that we saw very early on is that there were very, very, very few such patterns. In fact, most of the time, and you see this in looking at Calvin and Zeisel from the judges' reports, most of the time, if a straw vote is taken and it's 8-4 in favor of, say, guilty or not guilty, etc., it's going to be, the final verdict will be the way the majority has initially said. Again, most of you are too young, but for the few of us who are old enough to remember, there was a very famous movie called 12 Angry Men. And Henry Fonda was the leading protagonist in that movie, and he did something marvelous. The 12 Angry Men were members of a jury, and it was an ugly kind of murder case, if that's right. And when they went into the jury room, they took their straw vote, and lo and behold, it was 11-1 in favor of guilty. Now, guess who the holdout juror was? Our hero, Henry Fonda, and he did something that never happens on the jury. It makes good drama, but it doesn't happen. He then persuaded the other 11 people that the defendant was not guilty. That simply doesn't happen. In fact, what happens very rarely, and we've had some systematic studies about this, and you know this from other social psychological experiences, it's very rare for one person to end up even hanging in the jury. In the 12-person situation, if you need a unanimous verdict, it's very hard to withstand either the arguments or the pleas or the eloquence or what have you, and have one person hold out. Now, what am I generalizing from? Years before this, there was a famous psychologist at Dartmouth school in Pennsylvania, Swarthmore, who did a series of experiments. It's true, he did it with students, but sometimes we can generalize from students. And those are the famous experiments where he varied the length of lines and asked people to say which is the shorter line, and the differences were very clear, that, you know, there was a line this long, and then there'd be a line that long. Well, he had some Confederates who were involved in the experiment, and you would have situations in which the first 20 people would get up, and they would say that this line, which was obviously much shorter than this line, was in fact the longer line. Well, then the innocent, the real subject of the experiment comes up, and almost always the innocent also said, this line is the longer line. Because, after all, he looked around, or she looked around and said, who are these people that aren't crazy, are saying that this line is shorter? There must be something wrong with me. And most of them, in fact, said something which all their senses told them was not right. Well, I'm saying that in a jury, and a man called Charles Hawkins did a dissertation on this, said that you need somebody to agree with you. And this came out in the Ash experiments as well, that if you have one other person that says, no, wait a minute, I'm sorry, that's the shorter line. Similarly, in the jury, if you have one other person who says, I agree with it, I don't think he's guilty, or I don't think that defendant is negligent, etc. Even a coalition of two can hold out. So you will have hung juries of 10-2. Most frequently, the hung juries were where the division was close, 6-6, 7-5, even 8-4. But practically never would one person be able to hold out. And that doesn't mean that they were being hit over the head. It just meant that in most situations, it's hard for one person to be so sure that he or she is right. And we certainly saw that in the jury situation. Well, I've been talking a long time. Are there questions or comments? I can go on, and I will, but comments, reactions, questions? Yes, that is a pride of consistency. After all, I know how I voted in that deliberation. If I come out say something different on paper, even though there are no names on the questionnaires, that is, you start out with a number. If you're number 1 at the time we give the first questionnaire, and then when you sit down, we trace where you're sitting, and so we can adjust so that the pretrial questionnaire, where you're sitting and how you respond to third, we know who you are throughout. Even though the questionnaires are anonymous and they answer without anybody looking over their shoulder or anything like that, yes, there could be some of that. We found that there weren't that many times when jurors shifted from during the deliberation to the questionnaire responses. But we also listened to them during the deliberation. So in some ways we could see whether that was simply I'll be consistent no matter what, or whether there was content behind that. And having the deliberations, of course, were very important in that sense. Anything else along? Yeah. We wanted to find out how real jurors behaved, how rational were jury deliberations, how consistent. There are certain rules of evidence. I mean, for example, hearsay should not be taken into account. Opening and closing arguments are not evidence. You're supposed to listen to what the judge says about what rule of law you use. You don't have to follow the expert's opinion. You can listen to him and say it doesn't matter. Well, to what extent does the jury do its job? Now, while it's true that jurors only decide a relatively small number of all the cases that come into the courts, 10%. They decide the most important ones. They decide the ones in which either matters of principle or very often money or lives are at stake. And therefore, we don't know what goes on there. The jury deliberations are black boxes. Well, why are we spending all this time and money if we don't know what's happening? And many of the leading members of the bench and bar were saying, it's no good. They don't know. So what we were trying to do is say, let's find out how jurors decide cases. We know what they're supposed to do. There are all kinds of rules. Do they do it? That's what we were trying to do. And we were trying to do it under the most realistic conditions. In the 1920s and so on, there had been earlier experiments, again, using students, working out at universities, etc. Here was the most elaborate attempt to find out how a system works. And not an unimportant and not a trivial institution in the society. And the stakes were very high, because I think had the Chicago Jury Project at that time, or even subsequent studies of the jury, come out and say it's a sham. In fact, the jurors do talk about last night's baseball game. In fact, they're clobbering each other in the jury room. In fact, one person is dominating the jury. It would have led, I think, to a very strong movement for following the British system. We got the system from the British. After all, from their wisdom, they felt that the civil jury was too time-consuming and too expensive. Why shouldn't we follow them in that? That was the purpose. Well, let's... Well, let me try answering you in a couple of ways, and I'm not sure I'll satisfy you. One of the things that used to happen when various members of these jury studies would go around giving talks was, especially when we gave talks at law school. I remember my 3 days at Harvard, in which the best and brightest of the law students would look at me after I was through giving my description, and they said, "Oh, that's all very nice, but you know, it's all experimental. It's not real." And therefore, how can you generalize from that to public policy things? And I say, you're right, in the sense these have been cases that had been decided, and the jurors knew that. And then I say, let me play you some of the deliberations. And what people would hear would be absolutely stunning. If you can stun a Harvard law student, that's pretty impressive. Because what they would hear was the intense involvement of these people in the case. You would hear people say, look, if we can't arrive at a verdict in this case, it's going to cost the county money to retry, etc. Obviously not true. An experiment is an experiment. It doesn't matter. But people would become involved. We had jurors that would stay overnight and continue deliberating the next day because they felt, well, we're not ready to say that we're hung yet. We think with some more time. If the situation seems important, if the issues seem to matter enough, people will get involved in anything and work at it in as real a context as they would if, in fact, they were deciding someone's fortune or someone's life or reputation or what have you. And so what we were able to do is show in this context that we were simulating a real experience. Now, we had some other experiences, some of which were funny and some weren't so funny. We had some experts on our advisory team who said, yes, 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 but. And the but was, couldn't we compare them with real jury deliberations? How many of you know this story? You know this story? When we were in Illinois, because someone in Illinois wrote up the study. That happened enough time. We had very illustrious people on our jury board, David Bazelon, Ed Porter, various other people, Wexler, all kinds of noted lawyers and judges, etc. So reluctantly, some of us gained, I was not involved with this, although I did see the data. We gained the permission of a few judges, and some of them were in Kansas City, Missouri, that I remember hearing about, to actually bug real juries. That was the famous study. Because we finally thought, okay, here's the way of answering how real. This is the most direct answer. We would compare the deliberations of real juries with, well, the hundreds of jury deliberations that we had in various cities in the country. Now, we had a lot of people's permission to do that. We had the judges' permission to do it, and we had the attorneys on both sides' permission to do that. And they weren't very important cases in the sense they were civil actions, and not a great deal of money was involved. We did none of this with criminal cases. We did not have one group of people's permission, and that was the jurors did not know. These were hidden mics. And in fact, some of us then looked at the data and we examined the dynamics and the way in which decisions were made. And we all breathed a sigh of relief and we said, oh, goodness, it's the same, we're seeing the same kinds of things. And that was very exciting. And we reported this to some of the advisory committee. Unfortunately, Fred Strobeck went and gave a talk at the American Bar Association meeting. I think it was in Denver, Colorado that year. And this was, I think it's relevant because I think what happens afterward shows it's relevant. This was during the period of the McCarthy era and lots of scare tactics. And Strobeck gave this report. He showed how, in fact, we had the hidden mice, etc., the jury, etc. And some people became upset. And the people that became most upset was Alfred Jenner, who was a senator from Indiana, who was a strong supporter of Joseph McCarthy, and who was very skeptical of the worthwhileness of academia generally, didn't particularly like the law school at the University of Chicago, and didn't particularly like some of the people that were involved in the jury project. At least he made the association. These are people who are also members of the ACLU, etc. You think the ACLU has become notorious recently. Well, even in the late 50s, there were people who saw that as a dangerous sign, and he called for a Senate investigation. And so that's the famous study of which the Chicago jury project was under investigation, not for all the stuff that I told you beforehand, and not for this stuff that Calvin and Zeisler did, but for these few cases in which we in fact bugged real juries. As it turns out, we committed a crime so heinous that there wasn't any law against it. There was no law that said you can't bug juries. There wasn't a law that said you can. There was nothing. Then they wrote, there is now a law that says you can't bug juries, etc. But that was the kind of atmosphere in which we reported some of the results. And so the demands for how real is it, how useful is it, how important is it, were challenged by some of these kinds of things. So we did do that. We did play the deliberations. In fact, I think the most persuasive chapter in my book, The Jury and the Defense of Insanity, and people still talk about, is something I call the sound of the jury, in which I go through some jury deliberations. And you hear, I think, even though you're reading, you can almost hear how jurors talk about it. In the end, I think a lot of people were persuaded by the data. Now, another source of data, which I haven't talked about, but which went on during the deliberation, which went on during the project, is the Calvin-Zeisel approach to how you study the jury. And this is all reported in the famous book, The American Jury. We use many approaches, and by the way, it seems to me that has now become very accepted and desirable research strategy to study the same problem using many different strategies. In fact, we even have a formal name for it, triangulation and so forth. What Calvin and Zeisler did was say, we're not going to get involved in juries, in observing or studying juries directly. What they did was using a national sample of judges in trial courts all over the country. They tried to gain the cooperation of judges who would report to them over about a period of a year all the jury trials that were heard in their courtroom, and in addition to telling you something about the trial, civil versus criminal, weight of evidence, complexity of issues, who the defendant was, how many witnesses, were there expert witnesses, all kinds of things about the case that the judge would tell you about. The crucial thing that they used as their major dependent variable was, okay, how did the jury decide the case? And before the jury came in with its verdict, how would you have decided the case? And so that's the famous judge-jury comparison that I think many of you have heard about. And lo and behold, what did they find? Much to a lot of people's surprise. Somebody say something? But what is, we're all sophisticated quantitative analysts. The saying is not 100%. What they found was that in 80% of both the civil and criminal trials, and these are thousands of trials, judges and juries' verdicts were the same. They didn't examine damages in the civil. They were only talking about 4 plaintiffs and 4 defendants. But even more than that, they found that when they looked at those 20% of the cases in which there was disagreement, and they broke those cases in every possible way. For example, in the criminal cases, they said, maybe there's something about the type of crime that the defendant is charged with. Maybe there's more disagreement in rape cases, for example, than in homicide cases, or more disagreement in robbery than in kidnapping. Is there any variance among the 20% is what they were looking for. And so they made all kinds of distinctions. How about the characteristics of the defendant? Is it whether the defendant is black or white? Is that going to explain it? Even though 80% agreement is a lot and seemingly very good, they also wanted to see if they couldn't get a better handle on the 20% of disagreement, because after all, some readers could say, 4 out of 5 is so-so, but aren't you worried about the 20%, especially if there's something about those 20% which might make it, which might suggest that the jury wasn't doing as good a job as the judge. Okay, do you know what they finally came down to? And then they were able to handle about 94% of all the disagreement. They found a way of taking the judge's measures and saying, this case is very close on the evidence. That is, it really could go either way. The judges actually say, on any given day, I might have found for the plaintiff, and the next day I might have found for the defendant, or what have you. The evidence was that close. You really could find it difficult to distinguish. And then they said, How about cases that are hard? That is, they last a long time, there are lots of witnesses, there are all kinds of complexity, versus cases that they, the judges, these are not the experimenters, but that the judges would characterize as easy. Are most of the differences in judge-jury views going to occur on hard versus easy cases? Are they going to occur on cases in which you could say the evidence is so close that really there's not much of a distinction between the verdict that's consistent with the evidence and the verdict that isn't? Well, what in fact I found out, long story short, was that they could explain 94% of all the cases by looking at how close in evidence they were. And the disagreements occurred in those cases in which the judge himself said the case could go either way. So that rather than thinking in terms of 20% disagreement, in fact, much of the disagreement occurred only in those cases in which the judge himself would say, who knows, my colleague would have found as the jury found, and so forth. It was the Calvin Zeisel book, I think, that gave enormous credence to the legitimacy of the jury in this modern period. And the Judging the Jury book, which came out in 1986, so I'm not talking ancient history there, as they view all of the subsequent work that has been done on the jury. And they talk about jury competence, rules of law, expert testimony, all the kinds of things. Are jurors so taken with their own personal experiences and their own prejudices that they can't see beyond that, mad or bad, jurors in the defense of insanity. All the stuff that they look at, up until, I think, 86, comes out with a very positive evaluation of the jury. So that the stuff that we started in the late 50s and so forth, up until today, all suggests that the jury does a good job in applying the very complicated rules that they're supposed to in reaching a verdict. Yeah. Yes. Yes, and time consuming. That after all, if the judges and jury agree, why do you need a jury? Okay, and then the argument becomes, but in terms of, as a symbol of democracy, the jury is the only institution left in modern democracies in which ordinary people directly participate in important decisions. When you go out and vote, you're voting for a representative. That the jury has symbolic value. Now that's Calvin and Zeisel's argument, and other people agree with it. That if you're willing to say, look, if judges do as well as juries in such an overwhelming majority of the cases, why don't we go with judges? In fact, however, after that argument was raised, people said, but you know, the jury, now that we know that the jury does as well as the judges, we now come to the important political and symbolic reasons why we think the jury is important. And given its crucial role as a symbol of democracy, we would stay with the jury. Had you found that the jury doesn't understand the issues, that the jury's verdicts are irrational, that the jurors are not at all motivated to do their job, then the burden would have gone to, let's do away with it. But once you found that they do as well as experts, the other reasons, which are political and symbolic, for maintaining the jury is very strong.
I agree with that, but I think the biggest argument for the jury system maybe it's symbolic positive to be judged by jury fear. It does not promote equality of justice.
But it doesn't hurt the quality of justice. And the big question was, did it hurt the quality of justice? Nobody ever had argued that the jurors are better than judges. Nobody had ever said that ordinary people are better than experts. The burden of proof had always been that, what do you think we're experts about? And why do you think we spent all these years learning how to be lawyers and judges, etc.? Because we're supposed to understand these issues better. In fact, what all of the research shows is that ordinary people can go into a situation as amateurs and do the job that they're supposed to do. And that symbolic value is very, very great. I want to say a couple of other things. Now here we're talking about a very, very small number of cases, but again, they're cases in which the issues may be very important, and that is the fear that it's easier to get to one person, even though she is an important, distinguished jurist, than it is to get to 12 people. And therefore I'm talking about tampering with justice. I'm talking now about coercion or blackmail or what have you. And the feeling was that if we know the jury does its job, that again it's a bulwark of democracy, because if you have one juror who's been gotten to, you still have to deal with the other 11, whereas if it's a judge, the concern in many communities that perhaps the judge will be more of a target either for corruption, bribery. In addition to that, in the United States, many judges are elected. And would an elected official in a complicated, controversial case be able to withstand public opinion if he or she came down with an unpopular verdict? Is it not better to have that unpopular verdict handed down by peers, more than one peer, by peers who are ordinary citizens in the community? So once the evidence was in that the jurors could do the job, technically, and wanted to do the job, then the other values of the jury took on greater importance. By themselves, they probably could not have had a policy effect. Yes. We did a little of that on the experimental cases in which we actually had judges coming in on the same kinds of trials, and they're coming down with a damage award versus, we didn't do it in the criminal, but in civil. And we compared some of that. Now, all I can tell you is that those data are available in the Calvin Zeisel civil cases, which have never been analyzed. So to the best of my knowledge, there's not been any long-term systematic analysis of damage awards or sentences in criminal cases comparing judges and juries. I think it would be useful. Now, in many jurisdictions now, it's the judge who hands down the sentence. And I think fewer and fewer juries are responsible for sentencing. In some death sentence cases, I know they are. But there is, one of the things I wanted to say is that there is a great deal of data still available that has not been analyzed. And it goes to particularly the damage awards and the comparison of judges and juries.
Look at all the practices of jury nullification.
Yes, yeah. You all know about jury nullification, how jurors in Prohibition era and so forth. We had tried that in a couple of instances in some of the experimental things in two ways. In the defense of insanity trials, and there were a couple of them that I worked with, we had a version of the trial in which we gave the jury no instruction on criterion of responsibility. And we said to them, you can either find the defendant guilty or not guilty by using insanity, but it's up to you to decide how you want to do that. We didn't give them McNaughton, we didn't give them Durham, we didn't give them ALI, and certainly we didn't have an opportunity to give them the recent standards which emerged in the after the Hinckley trial. And we listened to how juries went about trying to decide what was the appropriate standard. Now that doesn't go directly to nullification, but it gave them a chance to say, well, you know, there's some jurisdictions that use right from wrong. And what's good or bad about that? That was mostly how they then compared it. And then in some of the civil actions, we gave them some opportunities in which we can say, we're simply not going to follow that rule. And we've listened to their discussions about it. We just think that's outrageous, and we're not going to do that. We didn't have anything as dramatic as Prohibition or some of the other kinds of cases that have raised the jury nullification issue. So important, like the fugitive slave law or something like that, and the juries do that a lot.
There's many variations of
No, the variations that we used were standards of responsibility, whether they would know something about what would happen to the defendant if they found one way or the other, variations in insurance mentioned, and what happened. We had one in which the plaintiff's attorney asked for a mistrial, and did the jurors, when the judge instructed them, we had a situation like that in the jury I said, the judge instructed them, disregard that. To what extent do juries disregard? Do they not talk about it? How does it affect their verdict, and so on? We didn't do anything on the main issue of nullification. One of the things that we obviously spent a lot of time looking at, after all, many of us were social psychologists working on the experiment, was does it matter who you are on the jury? We all, in those situations that we worked in, when we needed a unanimous verdict, every vote counted, and we could see to what extent some people spoke more or less on the jury room and in the jury deliberation room, and also whether talking more meant you had more influence. But also we were able to systematically look and see whether your status in the larger society, whether in fact you were that vice president or you were a secretary or a domestic worker, an unskilled worker, to what extent you had more or less influence on the jury. And while we found that persons who were used to talking more did talk more, we could see no relationship between how much somebody spoke and how influential they were in terms of guiding a jury to its verdict. Because we could look and see at the pre-deliberation verdicts on the part of people of various statuses, we could look and see what happened in the deliberations, and we can then look and see and how the final verdict came out. And so the fact was that even though you're used to talking, it doesn't mean that you're going to wield more influence than someone who didn't have your education or didn't have your professional skills. Nevertheless, they would be wealthy. The wealthier, more influential persons in a larger society did not determine those verdicts. And that was not an important finding. As you also know, there are shelves and shelves, maybe libraries, full of what lawyers call cookbooks on how to choose the jury. And now we have all kinds of experts, Jay Shulman and others. In fact, there are whole societies that have been formed. I've talked before, some of them, I'm not their favorite person, which says if you have us sitting next to you, usually it's next to the defense attorney, because many of these people do it out of the best and most generous of reasons, they will help you choose a jury. And what they're saying is we know enough about the mixture of personality characteristics, of socioeconomic characteristics, of demographic characteristics, of just observing people, that we can help you choose a juror that will be best for your side. You also know that the most famous of the trial lawyers, certainly the 1930s, Clarence Darrow, and later on F.E. Bailey, Louis Nizer, and Melvin Belli, all the, quote, big personalities, they all view themselves as excellent amateur psychologists. Nizer says in his book that the most important thing I do for my clients is choose the jury. That in fact, the voir dire is the most important set of decisions that they make, and after that, it's relatively straightforward. And these experts now tend to say, terribly important, who you get on the jury. Well, we looked at this very, very carefully. And in fact, in one section of the stuff that I was writing, I listed all the recipes that lawyers wrote about in the cookbooks. We call them recipe books, about how many men and women you should have on the jury, when you want women, when you want men, whether you want older people or younger people, blacks or whites, whether you want people of certain occupations, railway men, for example, some earlier period, was viewed as the most objective and careful of jurors, that they could really somehow collect all of the most complicated details and give it back to you in the most accurate way. Accountants were going to play some role, etc. We looked at all of these things and said, okay, we have all of these data now in systematic form. That's what we are collecting in the pre-deliberation questionnaires. Everything about these jurors. Now let's look at a macro level on how men versus women vote in various cases. Let's look at racial differences. Let's look at income differences. Let's look at religious differences, etc., and see what comes out. We know that in certain areas, we know, for example, in voting behavior, that these characteristics matter. You know that in terms of predicting elections, if you're into a heavily black area, certainly since the latter part of the New Deal, that's likely to be a strong Democratic area. You know that if you're into an area in which there are a lot of working people, particularly unionized working people, that's going to be a heavily Democratic area, and so forth. We think we know something about the role that religious differences may play in this, and so forth. Okay. So we said maybe it works the same way in the jury. Maybe, in fact, it's that straightforward by now. Maybe, in fact, if we know enough about the demographic characteristics, we can, in fact, predict jurors' verdicts, and from that, the jury verdict. Well, it turns out that what goes on in the jury room is sufficiently complex, and the stimuli that they're examining are more complex than whether you vote for candidate A or candidate B. And the results that came out, and this caused a great surprise to many of the more famous of the trial lawyers, particularly those who in fact make their career out of being in the courtroom and being on in the courtroom, was that the differences were not really this great. There were practically no differences between how men and women decided cases. The age differences made very little difference. Education didn't play nearly as much of a role. In fact, yes, there's some differences. Yes, some characteristics matter slightly more than the others, but the shading was so much finer than anything one could have expected from reading the cookbooks that I think for some of them it made them stop and think. For the others, I think we were least effective in that area of the work, because it's just, I suppose it's the challenges in the sense of we really can tell, we really can predict human behavior. The challenge there is so great that I still think, in fact I know that the business of helping you pick a jury is in fact boom. I think that if you look at the data, it shows that it's the quality of the case that is going to be much more important than the characteristics of the jury. Yes?
With the jury in what particular aspect of each, like say you've got a case where someone's suing you or a hospital.
Yeah.
Your characteristics versus what they felt was most important.
Yes, we did. We did. For example, does it matter whether the defendant is a corporation versus an individual, and who the jurors are? We looked at those kinds of things. We looked at the characteristics of the plaintiff. We looked at the kinds of cases involved, the situations involving the defense of insanity, exposure pleading insanity to a property offense versus insanity to an incest case. And people have different standards for what's crazy, for what's insane under those situations. When Calvin and Zeitzel had their thousands of cases and they looked at the verdicts, they looked at the combination of defendant characteristics, they looked at the kinds of witnesses that were involved, etc., to try and get a mix on this. Right. And now he found that he's had to introduce greater complexity into his model. Yeah. In one of the most famous cases early on in which experts were brought in, it was in the Harrisburg 7 trial. Not only did you look at the characteristics, this is the trial of the burning of draft records and so on in Harrisburg, Pennsylvania, and it was one of the more famous of the civil disobedience kind of trials in the 70s. Jay Shulman and Christie were involved as experts for the defendant. Well, they did a community survey because they wanted to see to what extent the jurors views might or might not reflect the community's views, and they looked at the religious differences in the community and looked at a whole slew of things to try and help them pick the best kind of jury in that. It has become a very, very elaborate and lucrative practice.
Did you find anything about jury students getting time?
Yes, they had. That's interesting. Yes, because you listen to them on tape and then you talk to them afterwards, and they have a sense that somehow they failed. That somehow it was their job to arrive at a decision, and not being able to was very troublesome to them. Yes. There is the sense somehow we haven't done our job.
I remember reading some time ago that some corporations in California had begun practice and they would bring out juries in.
Yes, I read it in Time magazine. Yes, a telephone company I think was doing that. Yes. I think it's a very interesting process. Now, how much they learn from that, we haven't really tested it, but it goes, it speaks to the whole mystery and the aura of the jury. It's somehow an institution that's absolutely fascinating to people, and to go to that much trouble, they'd actually do a kind of run on what arguments would be the most effective and so forth. I haven't seen any other analysis of that, and I don't know that anyone has studied that. You can imagine that it would open up an enormous industry if, in fact, for major corporations, every time they knew they were going to go into court with a jury trial, they took weeks and they could try their best arguments, and they can ask. They can get constant feedback. What really moved you the most? Should we drop that out of the opening or closing arguments? Should we include that? Which witness do you think was the best, and so on? The possibilities are endless. I was just absolutely fascinated, but I haven't seen anything else happen to it. Another thing which some of us try to do, but we can't seem to get the cooperation of the court. There are two things. One is the whole business of shadow jury. That is, for all the people who said, yeah, but it's not real, this experimental stuff. It's true, it's very powerful that you can get 20 different juries all responding to the same stimuli, but still they're experimental. How about getting 3 juries in a real case? Now, only one of them is going to arrive at the verdict, but no jury knows which one it is. It's the notion of the shadow jury. So in a real courtroom, in a real case, you have 12 people sitting in one jury box and 12 people sitting in another. In fact, now with only 6-person juries, maybe it is even practical, feasible. Wouldn't it be interesting to see how, in fact, more than one jury decided a real case right then and there? No tape, no simulation, etc. There have been no jurisdictions that have allowed this. Once in a while you get a judge who say, well, I'll try it once, kind of thing. That was something that Geisel has been pushing for years. I tried to get it in the District of Columbia and could not get any cooperation. Now I'll tell you the other thing that I think still needs to be done, and I in fact am very critical of the design of the Calvin Geisel study, and I think that needs to be replicated, and I haven't been able to get any support for that, although when I talked to my friend Marshall about it, he said, absolutely. What did I tell you about the Calvin Geisel study? I said that they sent out questionnaires to judges all over the country and said to them, would you for every jury trial that occurred in your court for some period of time, and I think it may have been as long as a year, would you keep records and report the jury's verdict in your verdict? Well, there are 2 things about that. One, I didn't tell you, and that is they only got 11% rate of return, because it's an awful hard job that they're asking the judge to do. They weren't saying for the next 5 jury trials. They were talking about a very long period of time. Now, what do you make of that 11%? Is it simply that it's just too hard, too time-consuming, or is there something special about the 11% of the trial judges that agreed to do it, and therefore what are we generalizing to? Something else that I think is more serious, and I was hoping one of you would raise it,
is that, what did I tell you about the design? I said that the judges were instructed that they were to indicate what their verdicts were before the jury came in with theirs, and then report what the jury's verdict was, and then, of course, Calvin Zeiss and everybody else working the project would be able to see to what extent there was agreement. Well, let's assume that these judges are honest, upstanding people of integrity. Isn't the temptation very great to either wait until the jury comes in with its verdict and say, yeah, sure, I agree with that, or to indeed perhaps put down what your verdict is, and then the jury comes in with theirs and says, yeah, I'm thinking about it. Anyway, I think we need a better, stronger, more independent measure of judge-jury comparisons. And I have tried in the form of proposals, and I got a small group of judges in Richmond, Virginia, to participate with me, and then I got a couple of other individual judges to participate. The judges would indicate what their verdict would be in the case while the jury was still deliberating, and we picked up the judge's verdict before they heard what the jury's verdict was, and then we got the jury's verdict, and we compared then judge-jury reactions. And it's a very small number of cases, so I don't want to give you the number. All I can tell you is it was different in the Calvin household. It was less. And I'm not usually cynical, and you know I've just given you a strong speech in favor of the jury. Nevertheless, I think that design needs to be worked on. I don't think the measure is a clear measure. I think it's a very important problem. Yes.
Another country
Yes. Yes. And now they're allowed to ask questions in open court.
So has there been any
Yeah, I think those are very important issues. For example, in the 50s and early 60s, jurors were discouraged from taking notes because the argument was that who knows whether your notes that you bring in court are accurate. But nevertheless, you say, now wait a minute, I have in my notes. Well, suppose in fact you wrote things down that were not what took place in the court. Nevertheless, you're saying, here are my notes, could in fact have an unfair influence on the jury. So that was always the argument whereby jurors were not supposed to take notes. Now the trend has gone the other way. In fact, jurors are given small pads of paper and encouraged to take notes during the trial and indeed to take their notes into the jury room. And what effect that has, we don't know. We also don't know, and this is less common, but it's beginning to happen, where jurors can ask questions in open court. That's a throwback to something that used to happen a very long time ago when it was very commonplace. We don't know. Lots of things to still say. Any other?
One last question.
Yes. Yes, we always look at that. Yes, there was very high similarity, yes. And the juries always asked that question afterwards. Yes, there was very close similarity.
Thank you. Please, we're all invited to go next door for the reception.
You're welcome. Hello. Well, I enjoyed looking at you because your facial expressions were wonderful. So, I'm glad. Thank you. Thank you very much. Well, I'm delighted. Thank you very much. You're welcome. Did I answer your skepticism? You thought your question was a good one.
I thought the last one was missed, mostly.
We were pulling the political trial.
Yeah.
Is it possible to get a copy of that article or whatever that you...
Actually, it appeared in Sociological Inquiry as an article, and then I incorporated it in the book.
That's creepy.
I was going to say, if you have a Xerox machine you want to Xerox it, otherwise I can send you a reprint of the article. Okay?
That would be great.
It appears. Okay, let me send you a copy.
Here you go.
Good.
You can just send
Yes.
it to City Center.
Yeah. Okay. Okay.
Thank you. I sure appreciate it.
Yeah.
We just leave it
All
here.
right, fine.
I'll come back.